Good day, everyone. We are now living in the IT era. It is important to discuss about the information control and privacy. This presentation shall help you to know more about intellectual property and know your intellectual property rights in the Philippines.
Under the intellectual property, we are going to discuss about its core idea, types, characteristics, and importance. Next, we are going to introduce the Intellectual Property Code of the Philippines, intellectual property rights, and the Republic Act number 8293. For the first part of our presentation, we are going to learn about the intellectual property. Intellectual property refers to the creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images. The concept of intellectual property relates to the fact that certain products of human intellect should be afforded the same protective rights that apply to physical property, which are called tangible assets. Most developed economies have legal measures in place to protect both forms of property. Let's discuss the types of intellectual property. Patents, trademarks, copyrights, and trade secrets are valuable assets of the company, and understanding how they are created is critical to knowing how to protect them. A patent is a government-granted monopoly to build, sell, and use your invention to prevent others from doing so. A trademark can be any word, phrase, symbol, or combination of these things that identifies your goods or services. In other words, it's how customers recognize your company in the marketplace. Copyrights protect original works of authorship, such as paintings, photographs, musical compositions, sound recordings, computer programs, books, blog posts, movies, architectural works, and plays. And last, a trade secret is typically something not generally known to the public, where reasonable efforts are made to keep it confidential, and confers some type of economic value to the holder by the information not being known by another party. What are the characteristics of intellectual property? We have here intangible property, rights and duties, creation of statute, territoriality, assignable, dynamism, subject to public policy, subject matter of IPR protection. What is the importance of intellectual property to business? For many business, intellectual property protects more than just an idea or a concept. It protects genuine business assets that may be integral to the core services of the business and overall long-term viability. How can intellectual property protect the rights of inventors, scientists, and artists? Inventors, designers, developers, and authors can protect the ideas they have developed by means of copyrights or patents. The aim is to prevent others from wrongly profiting from their creations or inventions. It also gives them an opportunity to earn back the money they invested in developing a product.
Now, it is the chance to know your intellectual property rights in the Philippines. The Philippine Constitution recognizes the need of an effective intellectual and industrial property system for the growth of creative activities. To that aim, it calls on the government to defend and secure the exclusive rights of scientists, inventors, artists, and other brilliant persons to their intellectual property and innovation. To carry out this obligation, the Philippine Congress approved the Intellectual Property Code or Republic Act 8293. The Intellectual Property Code of the Philippines umbrellas 7 rights, namely copyright and related rights, trademark and service marks, geographic indications, industrial designs, patents, protection of undisclosed information, and layout designs, topographies of integrated circuits. And the Republic Act number 8293 is divided into 5 parts. Part 1, the Intellectual Property Office. The Intellectual Property Office is divided into 6 agencies that help the implementation of RA 8293, and it is headed by a director and assisted by an assistant director. These are the Bureau of Patents, Bureau of Trademarks, Bureau of Legal Affairs, Documentation, Information and Technology Transfer Bureau, Management Information System and EDP Bureau, and lastly, the Administrative, Financial and Human Resource Development Service Bureau. Now we're going to the part 2, the law on patents. Chapter 2, Patentability. Patentability is having the quality to offer exclusive rights for the benefit of an invention or improvement granted by the government. Some examples of non-patentable inventions are discoveries, scientific theories, and mathematical methods. And in the case of drugs and medicines, the mere discovery of a new form or new property of a known substance which does not result in the enhancement of the known efficacy of that substance. Well, some examples of patentable inventions are products such as machine, device, an article of manufacture, composition of matter, or a microorganism, and process or method such as method of use, method of manufacturing, a non-biological process, or a microbiological process. Any public disclosure by any person before the filing date or priority date, if priority is claimed, of the patent application can be cited as prior art when assessing novelty and inventive step. So what is inventive step? Having regard to prior art, it is the step that is not obvious to a person skilled in the art at the time of the filing date or priority date of the application. There are, however, exceptions in which a public disclosure prior to the filing date of a Philippine patent application is disregarded. Chapter 3, Right to a Patent. The right to a patent belongs to the inventor, his heirs, or assigns. First to file rule. If two made the invention or applied for a patent separately and independently, the right to the patent shall belong to the applicant who was the earliest filing date or priority date. Inventions created pursuant to a commission. The person who commissions the work shall own the patent, unless otherwise is provided in the contract. Right of priority. If a person previously applied for a patent in another country, then their applications in the Philippines shall be considered filed as the date of the foreign applications. Chapter 4, Patent Application. The patent application shall be in Filipino or English and shall contain the following: a request for the grant of a patent, a description of the invention, drawings necessary for the understanding of the invention, one or more claims, and an abstract. Now here are some patented inventions in the Philippines. Plastic to diesel converter by Jamie Navarro, Challenge 21 by Leonardo Mejia Yu, and bus-built modular housing system by Edgardo Vasquez. Next to the law on patents, the law on trademarks, service marks, and trade names. How marks are acquired. According to the law, the rights in a mark shall be acquired through registration made validly in accordance with the provisions of the IP Code, and a mark cannot be registered if it is contrary to the public and the public interest. The technical and moral factors of the designs are also considered. Certificates of registration. According to Section 138, a certificate of registration of a mark shall be prima facie evidence of the validity of the registration. Prima facie evidence is the evidence which is sufficient to establish a fact or sustain a judgment unless it is rebutted or contradictory evidence is produced. The law also specifies the actions, damages, and injunction for infringement. Infringement is the unauthorized usage of a mark that is identical or deceptively similar to a registered trademark. Trade names or business names. A name or designation may not be used as a trade name if it is contrary to public order or morals, and if it is liable to deceive trade circles or the public as to the nature of the enterprise identified by that name. Penalties: a criminal penalty of imprisonment from 2 years to 5 years and a fine ranging from 50,000 pesos to 200,000 pesos shall be imposed on any person who is found guilty of committing acts of infringement. So in 2019, a fast food joint was spotted in China that imitated aspects of a Filipino-owned fast food chain, Jollibee Foods Corporation. In awareness of the Jollibee, the Chinese fast food joint, JFC reported infringement on its trademark rights under the Intellectual Property Code of the Philippines. Now for the fourth part, the law on copyright. Literary and artistic works, referred to as works, are original intellectual creations in the literary and artistic domain protected from the moment of their creation. Derivative works are the works of dramatizations, translations, adaptations, abridgments, arrangements, or other alterations of literary or artistic works. So under this law, no protection extends to any idea, procedure, system, method or operation, concept, principle, discovery or mere data even if they are expressed, explained, illustrated or embodied in a work. Also to the news of the day that or other miscellaneous facts having the character of mere items of press information. And according to the Section 185, the fair use of copyrighted work for criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright. This law also protects the rights of performers, producers of sound recordings, and broadcasting organizations. The provisions of this act shall also apply to works that are to be protected by virtue of and in accordance with any international convention or other international agreement to which the Philippines is a party. The Internet has been one of the major threats to copyright for a long time. So for example, CTTO. It is an acronym that stands for Credit to the Owner, and it is widely used on social media. While the Philippines intellectual property regulators has continuously warned the users to stop this practice. When using the acronym CTTO or any similar variation, you are not only disrespecting the original creator of the content, but you are also in danger of sharing fake news. With how prevalent fake news and misinformation are now, not verifying the information and its source can easily lead to a wider spread of disinformation. For the final part of the Intellectual Property Code of the Philippines, here are the final provisions. The Intellectual Property Code of the Philippines has been taking effect since January 1, 1998. To preserve the existing rights, it did not affect the enforcement of rights acquired in good faith prior to the effective date. Since then, all acts and parts of acts that are inconsistent are hereby repealed. Thank you for listening. I hope you learned a thing or two about the intellectual property.